the presentations to have more. Also, we changed a bit the topic. We will try to add to each other, supplement each other going through the presentation. Main thought was the following. Many things are happening at the moment in this area, already took place and will take place in the nearest future. That's why we thought it would be interesting to touch upon the amendments that came into force in Latvia, as well as about those things that are still planned to do, where there will be new systems, where there will be amendments and reforms, as well as on activities of European Commission that is indeed very active, because so many legislative acts from European Commission has not been adopted simultaneously or in such a short time in the history that we could remember. This is the outline of what we are going to talk about. The main things that came into force this year: amendments to the patent law that came into force with a goal to have also connection with Unified Patent Court, as well as which will be our regional patent court that was created in Sweden together for all the Baltic countries and Sweden, and that had to be placed into our legislative act in order to understand where disputes will be resolved, as well as some procedural issues that were solved. One of them decided in court, namely on maintenance fees, as well as specific deadlines, because there we also had some problems from practical applications point of view. That's why we came up with a more precise wording. This is the last date of a month, indifferent of whether it is a weekday or weekend, because we have had some issues and cases when directly from the patent owners, they didn't pay until the last day, and they said that it was Sunday. We wanted to pay on Monday. So this is out of the practice that is applied generally, and that the term now specifically last date of a calendar month. And also interesting personal data protection issues. There was a great mixture and great discussions, but somehow we managed with our national responsible office to include the wording that is necessary. And speaking about these amendments, General Patent Court, there will be some regulations changed as well and reworded. On the article, on the bullet point 1, amendments to civil proceedings law, I could talk about it for hours. It might impact courts as well, but the problem issue is connected with amendments to the civil procedure law, where unfortunately there is a missing regulation. We wait for amendments to be appointed in order to understand the disputes for industrial property, and when the appeal board's decision is being appealed, and there is a reference in what order civil procedure will take place, but in civil procedure law this is missing. And we do have active cases, pending cases, but if there is no regulation and civil proceedings law does not provide for it, then courts will be in the meantime obliged to interpret the law But what we've managed, there will be a separate chapter in civil procedure law where will be dispute resolution in industrial matters after the decision of the appeal board, and as well as there will be some new features. And concerning patent applicants' request for them to claim expenses to be recovered. Now we just think how it should be done, but the working group actually is in favor of such an amendment that will be enclosed in the law. Concerning temporary empowered persons, this is the list of such persons, which is closely connected with so on the list of patent holders and the order of the exam, it will take some time, but we are in the way to simplify this patent board's exam. At the moment, it's kind of a dialogue. But they themselves want to have more stringent requirements, and we want to simplify it. We believe that the specific profession wants kind of to make their profession more exclusive and less patent agents to be there, because the exam is very stringent, and we want to broaden the scope of the profession to have more patent agents. But yes, indeed, it is closely linked with financial motivation. It is quite an alluring profession. So, and one of the big issues is expected amendments to trademark law. We already touched upon non-agriculture goods geographical indications coming into force in the EU, and now we have interim or period of 2 years, whether registration process will be a national or we give it to WIPO, and we do have to tidy all the regulation concerning supervision as well as breach resolution. Quite a complicated process. The deadlines are until this year. We will have to announce about the registration stage, whether we keep it or delegate it, and until next year, then accordingly we'll have to amend all the or supplement all our legal acts. If you have any questions about that, I can answer, but if not, we can move on. What was already mentioned, one of the big initiatives was design reform. Commission amended both regulation and directive. The amendments are quite extensive. Maybe the result will be a completely new law. It is still decided upon. But taking into account that also procedurally we will have to change quite many things, our working group is quite busy at the moment, thinking whether to amend and reword or come up with a new one. So we have this as a homework: appeal boards, decisions appeal, and the order of appealing appeal boards' decisions. And we still have our homework to do, how to get to cassation in order to avoid other bodies and institutions. And then one more thing, to change the law on scientific work, how to commercialize your scientific work. Most probably there will be amendments, and according, there will be a cabinet regulation. I will not start to talk about that at all because it's quite a sensitive issue. I can talk for half an hour about that. We usually, when we talk about patent area, this is indeed the basics for patents to appear scientific work, and we think that it's not correct or not honest to say so, but at the moment no one wants to take upon themselves responsibility. The ministry is concerned somehow want to wash their hands off and they make situation even worse. And we are very glad that the Ministry of Justice, as well as the Academy of Science and all our academia joined together in order to develop innovation and drive innovation and strengthen it with the legislation. Very quickly this year, we are planning to report to the Cabinet of Ministers on patent system. We have this system, but we have to make this quality system better. It goes hand in hand with scientific work law, because we cannot just change the patent law and accept some patent applications without it, the scientific work to be allowed to be patented. And many organizations, including World Intellectual Property Organization, are helping us to eliminate the shortcomings. And I hope that further on we will be much faster to organize our reforms. We take into account all possible areas of intellectual property, not only what we are doing, but also what the legislator does, what the executive power do, small, medium enterprises. So we take into account all the scope of intellectual property area. Also, you've probably heard that for many years we are preparing so-called Judges Academy. I'm not going to talk about that in great length as well, but our goal was to indeed be present when elaborating programs for this academy, for these programs to involve and to include questions on intellectual property. They were not existent there. Thanks to Zana and the Supreme Court that stood for us and agreed that those are very important for new judges to cover these subjects. And I hope it will result very, very soon with indeed programs including patents and IP. And I am very glad that we have support from WIPO, who is helping us to adapt our training material or guidelines for prosecutors and law enforcement agencies. Our prosecutor's office was very supportive. Our own prosecutors were those who adopted these materials in order to use the materials and ensure this training process developing themselves. And I hope they will make also the police and other law enforcement bodies to engage into these activities of training themselves on IP matters and IP crime. And I hope it will result already in something tangible this year in November. On strategic plan, here we have to cooperate both organizations, and we've worked on the plan, and we actively work also on a strategic plan for WIPO and EU WIPO that will be finished, I hope, this year, because many things how our organization is working with us and with other EU patent offices are enclosed in those documents. And our suggestions from other member states have been taken into account, so we regard these strategic plans very positively. I will take over from here. As it was already said, with the European Commission has been very active this year. Last year in spring, we have 3 new regulations concerning patent law, patent protection, 2 absolutely new on significant patents and forced licensing, as well as 4 on additional protection certificates. Our goal is to be more and more efficient, but more understandable and simplified with less bureaucracy. That's why one of the fundamental changes that was suggested, namely that a centralized body will be EU WIPO. This issue was most discussed, taking into account that EU WIPO did not or does not have such a big experience. Of course, that it will take place in cooperation with national offices, but this is the issue that is still mostly discussed. The gain from this centralized institution, they would be mediators on front licenses, these big licenses, and centralized body to take a decision on issues whether we grant or we do not grant additional protection certificate. Now every country takes their own decisions that might differ, which is not a legal certainty for right owners and might be a lengthy and even a costly procedure. So the suggestion is that the decision taker will be EU WIPO, and we will be the executors of this decision. Now, the new regulation on standards for generic patents. What are the generic patents? These are basic technologies like Bluetooth. Bluetooth would not be anything without as such, but it is very important for a phone. So if it would be useless to put on a market a phone without Bluetooth. So that's why there should be a kind of patent price to pay for these additions. But this is a huge market, and even if the percentage is very little, it would still be significant. What do we want? Then this generic patent holder will be obliged to register themselves as patent owners. Other users will clearly understand this is a generic patent and it belongs to this company. Also, there will be available information on the price of this honest license. And EU WIPO with alternative dispute resolution will be mediators for front. This will be the mandatory obligation that ownership holders or certificate owners cannot be claimants themselves in the court. They will go through a mediator. We will indeed have a clearer system with these licenses, and there will be less risks to take something upon that we cannot afford. But in general, says Mr. Batalauskis, this area is quite different, and the situation in member states differ. That's why this process is not a simple process where it is clearly understandable where we move towards to. We move forward as if, but we do not know when. When these standards will be adopted. We hope we will do it during the presidency of Latvia in the EU. So we are kind of stuck with this regulation now. European Commission has ordered a new survey, a new evaluation. But next thing that there is already a general agreement on this regulation necessary for Europe on forced licensing. This is nothing new for member states. We have this forced licensing, but we do not have a mechanism, a unified mechanism during crisis situation affecting all the European Union. There are many discussions, primary ones. How are we going to limit ownership rights? But we want to think about a voluntary agreement before a dispute. We, at least in 10 places, added the words that this is the ultimate resolution if agreement has not been reached in any other way, and it will affect also patent applications, not patents only. We theoretically understand that patent applications are very important, and thus we can avoid or resolve crisis. We do have similar regulation in Latvia, but it has not been used, and I believe that other member states do have it. It is very seldom used. Indeed, but the main idea was, and what European Commission also said, this was a reaction to the last 4 years, namely that there should be a mechanism how it is possible for member states, if agreement cannot be reached, to appoint a forced licensing. Similarly, as we had with vaccines or any other issue, where public interests go over, then everywhere, and also Commission stressed it on several occasions that there should be a voluntary agreement. But if the owner says no, then there is kind of a forced mechanism, but also at the same time keeping fair remuneration. Remunerations have also been discussed. Initially it was 4%, but then we came to a conclusion that set percentage cannot be stipulated. But at least there will be a mechanism that it will concern the whole territory of the EU, not separate member states. Next block on additional protection certificate, centralized and genuine, general. concerning all member states, with the goal that all 27 member states will submit WIPO with an application, and WIPO will give an opinion to award the certificate or not. So we kind of ensure predictability and legal certainty. It will not be the case when one country awards the certificate and another country does not. Also, maintenance fees will lower, and all the interested persons will have access to information on awarded certificates. Also on EU WIPO, IPO experts, whether they will be competent enough to take these decisions, and whether our national experts' competencies will not be kind of diminished, and how we can involve national offices for taking decisions. These were also issues discussed, but they will be submitted to the appeal board and others. Speaking about these unified additional protection certificates, because they concern general or unified patent concerning those 18 countries who have joined unified certification. Slowly, we are joining. In the nearest future, it won't be all the countries, but our far-reaching goal is to include all countries. So we have a general patent court. We highly evaluate those judges, but we don't want in these proceedings or processes to be EU IPO, but this Central Patent Court to be involved or to be the boss. We are trying to how to do that, and the issue that has to be answered as how we can access this General Patent Court. It should be through national court, and this could be the question. And those countries who have joined, they could do that through national court. But it still is an open question, a main question remaining the issue of competency, and who is competent enough and whose competency it is to decide upon certain issues. And member states are not unified in these matters. European Commission opinion differs or is quite opposite member states' opinions, and these are the problems. The main problem is the following. At the moment, EU IPO is the only EU organization who could deal with our general issues, things, but the patent board, is kind of a voluntary union of certain member states who